Hi, good morning, everyone. Thank you for joining us. We're just going to give it a couple of minutes before we get started with the webinar. But for those who have joined already, thank you for being on time. Good. Everyone ready to start on our side? Quick thumbs up. Good. Alex, you good to go? Good. Well, morning, everyone, and thanks to everyone that's joined us. My name is Alexandra. I'm the head of projects, energy, and infrastructure at Bowman's Kenya, and it's my pleasure and that of my colleagues to welcome you to today's webinar being hosted by Bowman's. Today, we're delighted to speak to you about a topic that is both timely and critical for the future of energy in Africa. We're talking about navigating open electricity markets with a particular focus on market reform that's happened in Zambia, is imminent in Kenya, and obviously the valuable lessons that we can draw from what's been happening in South Africa. I think as many of you are aware, the electricity sector across Africa is undergoing significant transformation. Traditional vertically integrated utilities are giving way to more open, competitive markets. And the shift is driven by an urgent need to improve efficiency, attract private investment in what is a very tough economic and investment environment globally, but especially for the continent. And ultimately, we want to deliver reliable and affordable electricity to drive, obviously, industrialization on the continent and of course, light up homes for millions of people. Reforms are not without their challenges, obviously. There's regulatory uncertainty. We need to prepare for market readiness, and obviously having in place robust generation and transmission infrastructure is still a significant hurdle. So I think this is where we're going to learn a lot from what's been happening in Zambia, what's on the horizon in Kenya, and of course the lessons that we can learn from South Africa, who are probably ahead of the curve on private generation and open access. So I'm delighted to be joined today by my colleagues from across the Bowman's family. I've got, in no particular order of priority, but we'll start with Alexandra Felekis. Alex is part of our team in Santon. She's facilitated, I think, the closing of upwards of 3,000 megawatts of private generation in South and Southern Africa, but she'll clarify that for me. And she's advising numerous clients on energy market reform in South Africa. We also have Bwalya, who's a partner and head of the banking and finance practice in Zambia. Bwalya has over 11 years of experience advising clients on transaction and projects in Zambia. Bwalya and her team, together with the wider Bowman's team, we've advised clients on some complex and innovative transactions in Zambia. I think especially in the last, I'd say 12 to 18 months, we've seen a serious uptake of deal appetite and I think execution of really interesting projects in Zambia. And Bwalya and the rest of the team can talk about that later. And finally, we've got Edwin, who's glowing because he's newly married. He's off the market, ladies, for those who've dialed in. Edwin is also a partner in the Kenyan practice with me. And of course, he has a very strong track record of advising on transactions across East and Southern Africa. And I think Edwin's been definitely taking the lead on a lot of the complex CNI work that we've been doing here in Kenya. And is very much, I think, looking at spearheading a lot of the work we're going to do in private generation and open access. So that's all from me. Let me hand over. Initially, we're going to start off with a couple of presentations by my colleagues, and then from there we'll go into a panel discussion. But I'll let Alex take the lead from here.
Good morning, participants. Thanks so much for joining us today. We're going to start with Kenya. So I'll hand you over to Edwin for now.
Thanks, Salim and Alexandra. I think it's best we start with Kenya because we are the newest entrant into this open market system, and it's interesting to look at what is imminent and compare that to Zambia, who's been at it for a while, and take the lessons from South Africa. So at the moment, what we have on the screen is the current electricity market structure. Kenya has an unbundled energy sector with KenGen, a state-owned generator, at the very top with IPPs. These generate and sell power to the Kenya Power and Lighting Company, of course, through KETRACO, which is the state-owned transmission utility. There is also a thriving captive power market, but this is driven mostly by on-site generation, mostly through solar. There are a few wind projects, but essentially this is the structure that we currently have. KPLC, being the pass holder of the entire sector, is the dominant player. As I said, there are bilateral power purchase agreements, PPAs, with KenGen and with IPPs. So that's essentially a nutshell of what we currently have. And the idea is to transition to an open electricity market. And this is on the backbone of the Energy Act 2019. This progressive piece of legislation set up the framework for open access and a competitive electricity market. It includes a definition of electricity market being a market where generators of power, importers of power, have a market to sell this to customers and to other resellers. There's also a clear principle of open access, defined as the non-discriminatory use of all electric transmission or distribution systems by any licensee or customer. These create a good foundation for what is going to be an open electricity market. And the other thing I think is important to mention is that EPRA has also designated KETRACO as the system operator as we prepare to transition to an open electricity market. So the framework under the Act is given life through regulations, as we all know. And in February last year, the regulator published a draft of the electricity market power supply and open access regulations 2024. That was in February, as I said, but what we saw later was something quite commendable. They took a lot of feedback from the public and from the energy sector, and there was a further draft that was shared with stakeholders in the sector around December. That was a much improved draft and is the draft we're going to focus on as we do this analysis. So the December draft is yet to undergo formal public participation, which means that there's room for us and for other people in the sector to review this and provide feedback and comment as we try and get to a document that will work for the sector. Now, these regulations aim to give effect to an open and competitive electricity market, and to give effect essentially to what we've said is the framework or the principles that are there in the Act. Something important to mention before I move on to why we are transitioning is that the Act gives the general principles. The regulations will provide an overall framework, but fundamentally, the day-to-day operations are subject to what will be known as the electricity market guidelines and the operations guidelines, which will be published by the systems operator in consultation with the authority. So it's important to remember that, yes, the regulations are there, but much of the detail and much of our understanding of how it's going to work is going to come in the guidelines and the rules that are going to be published later on. So why transition? I think for IPPs, this will give them multiple buyers, better access to the market beyond KPLC, which is the current single buyer. There are a lot of stranded projects due to policy uncertainty that has been experienced in this market for the last 5 or so years. So that could be a way out for IPPs. There's an opportunity to scale up where, for example, you are limited by space on a rooftop of a customer. If you're able to build a plant somewhere offsite and then wheel power to your customers, that's a good opportunity. And of course, with better market access comes better pricing and flexibility around who you contract with. For consumers, of course, the hope is lower energy costs. You have a choice and flexibility on who to engage with as your supplier. You're looking at potentially improved service and reliability, and something quite important, although I'm not sure it's a big issue in this country because of the proportion of renewable energy we have on the grid, is some customers have sustainability goals to meet, and therefore they might choose one technology over another. And this is also an opportunity that will be given under the open market. For the government, more players in the market mean more competition and efficiency, reduce cost of power, of course, you address overcapacity and idle power. We have very rich resources in remote parts of this country, and those need to be transferred to areas of use. There's also the commitment to policies such as the establishment of the East Africa Power Pool. Getting to an open market is the first step to that. Now, let's look at what is proposed as the electricity market under the regulations. This diagram you have on your screen is lifted from the draft regulations, and it's a good representation of what we should expect. So you will have a centralized market that has capacity contracts and energy contracts. There's also an intention to have a separate ancillary services market, but this hasn't been developed, and I understand that the regulator is looking into this and doing a few studies around it. This market will be through bilateral contracts, spot markets, and forward contracts. As you can see on the very top right-hand side, you have existing PPAs, and those are directly with KPLC on a bilateral basis. The idea is that those will continue being on a bilateral basis, but every new generation represented by G1, G2, G3 at the very top is going to go through the centralized market. There's also the opportunity to do bilateral agreements between generators and eligible customers through bilateral contracts, as you can see from the farthest right. And essentially with an open market, you'll have a number of transmission network service providers, that is the TNSPs, the DNSPs, which are the distribution services providers, and several retailers. So customers will have a choice on who they buy their power from. And at each level of the market, we expect different participants. I think ours is a centralized market, but maybe Alexandra, you can touch on the multi-market structure.
Thanks, Edwin. I was just trying to, just give me a sec. Okay. So I think just from what Edwin's just described, what's really interesting about Kenya is in South Africa, in terms of open access and bilateral private generation, it's actually been, well, not a slow process, but in terms of regulations, it's been a slower process than what Kenya is looking to do. So for about 8 or 9 years ago, effectively the government facilitated the opening up of the market and use of the grid, and it's specifically private generation through bilateral arrangements between IPPs and then heavy electricity users within South Africa. So those sort of arrangements, both on-site, so behind the meter arrangements, captive arrangements, and open access private generation has been taking place for about 8 years now in South Africa, and that's because the regulatory framework became it's almost unregulated and very permissive in terms of the way that, and I'll talk about that in a few minutes. So Edwin's just taken you through the fact that Kenya's legislation is actually evolving the structure into a competitive market at the same time as opening it up for open access. So in South Africa, we've been doing that. A lot of projects have closed based on our framework. But it's only now recently, since December 2024, January 2025, that our legislation actually came into effect for South Africa to actually evolve from a vertically integrated monopoly structure where our state utility, Eskom, is the generator, distributor, and transmission company and effectively provides 90% of the electricity to consumers in South Africa, to a model where you have generators competing directly with generation and with retailers. And that's through the Electricity Regulation Act, and more recently, the draft market code rules, which will regulate that we would have, and this diagram depicts that better, where we would effectively have a spot market, a day-ahead market, and an intraday market. We would still have bilateral transactions that sit outside of that structure. And then we would continue to have regulated transactions. And by regulated, I mean there where the government actually procures electricity for on sale to, well now, because it's changed, the transmission of Eskom, which is the national transmission company of South Africa. So it's just noteworthy that Kenya's taken the leap at once. South Africa, we have done that more slowly. So we're also working our way through how our multi-market model will work. I would say that Kenya's model, if you look at this diagram and you look at Kenya's, it's very similar in the way that you have the spot market, you have bilaterals, and we're also contemplating forward contracts. So financial PPAs, contracts for difference, as being a core aspect of the model. South Africa, we've got a greater idea of how it's going to look because our market code has actually been issued for public comment. So that gives us a lot of insight in terms of how the spot market will work, how energy will be offered, how it will be dispatched, how it impacts bilaterals. We've got a lot more certainty. What I feel with Kenya is we have that overview there, we have the framework, but the rules aren't in place yet. So it's very difficult to say how different it is from South Africa at this stage. Once those rules are public, we'd be able to do a more detailed analysis. A noteworthy thing that came to mind for me when I was looking at Kenya's structure is the fact that you see there that Kentraco will participate in that spot pool, in the spot market, alongside IPPs. In South Africa, there's a lot of emphasis on Eskom Generation's participation in the spot market and making that generation available. And what we've actually got in our structure, and you'd see it on the diagram here, are vesting contracts, which is basically that Eskom's gen capacity and Eskom distribution's offtake as such is hedged by what we have developed as the single buyer, the central purchasing agency in our jurisdiction. And for us, that's quite a key element to mitigate Eskom, or the state utility who's the monopoly in terms of generation, to regulate their abuse of market power. It's unclear to me at the moment, just by looking at what's in the regulations, how that's going to work in Kenya. So that's definitely something to watch, and for everyone to, for us to be considering as as the regulator actually engages with the sector on how it should work.
Thanks, Alexandra. So from the draft regulations that we have, we've sort of tried to map out what a wheeling structure would look like under those regulations. And just to run everyone through this, at the center, we have your IPP or your generator or seller, and that entity will sign a wheeling agreement with the network service provider. Network service providers in this case are the transmission service providers and the distribution service providers. Under that agreement, wheeling charges will be agreed and other charges that will be applicable. So the IPP generates power, and through the NSP transmits that power to the eligible customer. And I think the thing to mention there is not clear, and Alexandra will talk a bit more about this, on how the eligible customer will get the benefit of the power, but that's something we'll discuss in a bit more detail. So essentially, you have your traditional PPA between the eligible customer and the IPP, where the eligible customer pays the tariff, and a wheeling agreement between the IPP and the network service provider. The other thing to note is that the regulator, the Energy and Petroleum Regulatory Authority here, plays a significant role in these arrangements. So as you can see, there's that list of oversight roles that it has on the right-hand side of the slide. From a network service provider perspective, you get your licenses, whether it's transmission or distribution, from EPRA. When you develop your access guidelines, those have to be approved by EPRA. When you prepare your wheeling charges or your network access charges list, that has to be approved by EPRA. And then again, although the draft regulations include a template of the wheeling agreement, as we go ahead, we'll see that that still has to be approved by EPRA. Again, for a generator, you get your licenses from EPRA. Your tariff is approved by EPRA. And this is the case whether it's a bilateral tariff between two, sophisticated customers, or with KPLC and a generator. You get your retail supply license. And again, as I said, there's the wheeling agreement, which needs to be approved. So that's generally how the regulations anticipate the wheeling structure will work. We can contrast this with what Alexandra has seen in South Africa.
Thanks, Edwin. So I think for those participants that are joining, from South Africa, you'd be familiar with this diagram, and we've also been through it numerous times. But I just want to start in the corner over there where we actually have that the IPP, procures a generation registration from our regulator, which is NERSA. So this is a fundamental difference. So and it goes to what I mentioned earlier about the fact that our regulations are they're very hands-off in terms of private bilateral arrangements. And it is one of the key reasons why we've had so much growth in terms of private generation, I'd say specifically over the last 5 years. So when open access was actually permitted in terms of South Africa, we still had a regime where a generator had to get, for a private generation project, had to get a generation license. And of course, then there had to be more regulation by our regulator on the power purchase agreement and the tariff. That was turned on its head a few years ago through an amendment of our Electricity Regulation Act, where the generator under private bilateral arrangement just actually has to register with NERSA. And the requirements are very light touch in terms of the interplay, or at least the monitoring by the regulator on these arrangements. So it really is a commercial deal between the consumer and the IPP. The regulator does not have a say on the commercial terms that are agreed in the PPA. And especially the regulator does not have a say on the tariff that's actually been commercially agreed between the parties. And that's very much if it's a bilateral. If there's a trader, there is it's regulated because a trader requires a trading license, but also not regulated, I think, to the extent that's contemplated in both Kenya and in Zambia. So I think that actually is a key takeaway for Kenya, in that we have very little regulation over private generation currently. And as the market evolves, we don't see that actually changing. It's actually needed for the market to become very flexible, voluntary, and competitive. Now, when it comes to how, the key question will be in terms of open access, how does the customer actually receive the benefit of the electricity that is then exported into the grid by the generator for the benefit of that customer, taking into account the fact that you are using the network operators line, and the projects could be in different provinces within Kenya. So this isn't clear in terms of the open access regs in Kenya. What we have in South Africa in wheeling is wheeling or use of open access. It's regulated by two key agreements. So the one is the connection use of system agreement, and that's up here between Eskom, the municipalities, and the generator. And this basically regulates that the IPP can connect into the grid, and Edwin's going to talk just about how that's going to occur in Kenya in a moment, and that it can then actually use the grid, and it pays use of system charges for doing that. In that connection and use of system agreement, the generator actually allocates which customers should receive the benefit of the energy, and that's very important. Then under then there is an electricity supply agreement between the consumer and Eskom, or a municipality in the South African context. And that electricity supply agreement governs Eskom, or the municipality, selling electricity to the consumer at its load point. Now that agreement gets amended to basically provide that an IPP is using the network to wheel electricity to you. For every kilowatt hour that's exported into the grid for your benefit, the customer will get a credit from Eskom in respect of that renewable energy on their electricity invoice. Now that's how the customer actually gets a cost saving on its electricity in South Africa, because it pays the IPP a lower rate than it pays Eskom, and Eskom then on its invoice gives it a credit. Importantly, it's not at the same rate as what the IPP sells the energy for. It's at the wholesale energy price in South Africa. But by applying a credit using that rate, the customer derives quite a significant saving in South Africa. So it will be very interesting to see in terms of the rules, in terms of, and how the system operator's role in effect in dispatching or making certain energy or capacity available to the buyer, how that interplay will work. Go ahead.
So I think one of the things we'll be talking to our panelists about is who can participate in this market, or who the potential participants are going to be in the Kenyan context if we get to a point where the open market system works. At the moment, eligible customers are defined to consumers who purchase power from a licensee, and the threshold that's been prescribed is 1 MVA in the distribution system, or 10 MVA in the transmission system. Alexandra mentioned about the role of the system operator, or the market operator in the SA system. Here we also have a system operator. As I said, EPRA has designated KETRACO as the first system operator, and KETRACO is going to have a very significant role in this market once it's in place. So you can see it's supposed to coordinate all the network service providers for scheduling and dispatch. It's supposed to, during the transitional phase, coordinate operations of the electricity market. I think something to mention is that there's no prescribed transitional phase, but the regulations say that participation in the centralized electricity market during the transitional phase shall be optional. The other thing the SO is going to do, it's going to develop the rules and operational guidelines. It's going to develop an online market portal for buying and selling between licensees, and also going to provide systems to match demand and supply. One fundamental difference we saw in terms of how the regulations contemplate open access is going to work and how South Africa does it at the moment was the process of applying for access to the network. So this is just a summary of the process, and as you'll see, it starts with the eligible customer or the licensee submitting an application to a network service provider for access. Then the NSP has 30 days to do a technical review of the application and then submit it to the system operator for a review and no objection. Then if there's no objection, there's a further 45 days to consider the application. And if it's rejected, then the applicant receives the decision as well as the reasons for why it's been rejected. If it is approved, the parties initial a willing agreement. As I mentioned, there is a draft of the willing agreement that's going to be in the final regulations. At the moment, it's just a list of the clauses that will be in the agreement itself. The initial agreement is sent to EPRA for approval, and EPRA has 60 days to review and approve this. So I think we can contrast this with the system or the process for applying for access in South Africa. And Alexandra can speak through this slide.
Sorry, I was just struggling to unmute myself there. Yeah, so thanks for that, Edwin. So it does appear from the Kenyan regulations that it is a first in line, first served principle. So that is where South Africa started with our grid access. And obviously in South Africa, grid access it's the most important thing. Without it, there effectively is no project. And as everyone on the call may know, that we actually suffer from capacity constraints in South Africa on our grid network, and that effectively makes it, even more fundamental in terms of how that capacity is allocated. So we started with, first in line, first served. It either proved inefficient because what you effectively had is someone who had applied, but maybe wasn't at the state of project readiness or project development readiness that they should have been in, could have sat on that capacity for in some instances they sat on that capacity for years. And there wasn't a process where our grid access unit could then easily withdraw that capacity and then give it to a participant that was actually ready, readier as such to actually generate electricity. So now it's actually changed to a process of first ready, first served. And this diagram, the next diagram, actually gives you a more detailed diagram of that. So I think it's not a perfect process. So I wouldn't say that the first ready, first served process is perfect. It does need some work and refinement. And I think that the biggest criticism that we have as the private sector in South Africa is, as much as it is codified and there is a policy, it actually, to be fair, isn't consistently applied by the grid access unit. But you'll see that it's quite a detailed process. There's a lot of steps that you have to get through, and you've got to be at quite a stage of project readiness to actually have capacity reserved to you in South Africa. So as a generator, you have to have your land rights in place. You have to have your authorizations. You have to have signed headers of terms with your customer. You have to have done preliminary designs. It does scrutinize the fact that when you're asking for grid access, that your project is actually real. It's a properly conceived project. Obviously, the way that it works is there's cost related to that, and that cost is substantial. It's not a minor cost. And there are guarantees that have to be issued in order for you to actually get capacity allocated to you, and to secure that the generator will actually do what it has to do within the time that it has to do it. And if it doesn't, then that guarantee can be called because of the cost that is incurred by our grid access unit in terms of the studies and the work that it's undertaken to get that capacity. Sorry, give me a second. To make that capacity available to the applicant. Now, that's a distinction, I think, between, I'll say it again when we talk about Zambia, but Zambia and Kenya. So it seems like it's a much simpler process. It doesn't really talk about any sort of payment as such. The payment, I think, the quotation fee that you pay, any sort of security that you pay any security that you provide the grid access unit in terms of that capacity, that isn't there in the structure at the moment. And I think that practice will show that, this will evolve, and through practice and engagement with the private sector, I do have to say that I don't think it will stay, it will maintain, it won't be as simple as it looks now in the regs, when the reality of it actually comes to play, and how you actually regulate this, so you actually are treating all applicants fairly, and you are, providing undiscriminatory access to all applicants. So also a space to watch, and obviously to the extent that there is that offer for engagement with the government on this, or what will be your equivalent grid access unit, something that should be there should be active participation in that.
Well, thanks, Alexandra. That's something clear for us to note. Now, just in the interest of time, I won't talk much about this. I think the important thing to note about the operations of the open market is that the parties to the PPA will be responsible for recovering the allowable energy losses. This will be prescribed by EPRA, and then your distribution or your transmission service provider is responsible for all losses above the allowable energy losses that have been prescribed. And to conclude, I think we can run through some of the open questions that we have in our regulations. I think the first one is around capacity or readiness of institutions to implement open access and the open electricity market. As we've said, KETRACO and EPRA are going to play significant roles to bring this to reality. KETRACO as the system operator and EPRA as the regulator. There are questions around whether we have enough capacity at the moment in these institutions to make sure that we have a system that works. There have been questions around the fact that KETRACO, being the system operator, is also going to be the KETRACO being a transmission service provider and the main transmission service provider. And we understand that KPLC is even transferring all of its transmission assets to KETRACO, is going to be impartial in its dispatch of its mandate as system operator. So that's still a question that's out there. We are not clear on how the transition is going to be in terms of time and process. There are questions around our network. Kenyans and those who have been following this market will know that we've had a couple of nationwide blackouts that have been blamed on the transmission system. So there are questions around whether significant investment is required, both in terms of physical infrastructure and ancillary services, to make sure that the open market works, the open electricity market works. There are questions around the charges. These are system charges and network access charges, and what those will be and whether they'll make wheeling viable from a commercial perspective. One of the things that came up as we were discussing this is that there's a significant risk of curtailment where the system operator may curtail power on any network, but it's not clear on whether there are compensation mechanisms if this happens. As Alexandra mentioned, we don't have clear guidelines for access, but from the reading of what is there in the draft regulations, it looks like it's a first come, first served basis. It's a first in line basis, and that it's a first step, but clearly, as you've heard from Alexandra, it needs to evolve to a fast ready approach. And again, also discussed by Alexandra is how the buyer will benefit from the energy that it's getting from the seller. So that's it on our on the Kenyan open market and electricity bulk supply regulations. I think we can have a look at Zambia and see how that will work, or how Zambia is approaching this issue differently.
Thanks, Edwin. So I'm going to hand over to my partner in Zambia now, Bwalya, to take you through the Zambian context. I think there's a lot of food for thought from Edwin's presentation, and we will open up for questions later on in the session. Over to you, Bwalya.
Thanks, Alex, and thanks, Edwin. It appears to me that the Kenyan open access regulations are certainly more comprehensive than the Zambian ones. There's quite a bit of detail in there that we're able to appreciate is not currently in the Zambian regulations or rules. But maybe just to start again, as we did with the Kenyan market, to say what is our market structure in Zambia. So we do have an integrated market, and currently, in terms of generation, you can have ZESCO, which is our largest generator, as well as different independent power producers. In terms of transmission, we currently have ZESCO and Copperbelt Energy, CEC. And then in distribution, we also have ZESCO and CEC. And then, of course, they are all both distributed to domestic consumers and industrial consumers. I think this is probably well known that, you know, the Copperbelt Energy Corporation is operating transmission and distribution in the Copperbelt region, whilst ZESCO does control transmission in the rest of Zambia. And for our market, the mining sector is our largest consumer, consuming over 50% of generated power. ZESCO is obviously a dominant player in the current market, and previously was a single off-taker to most of your PPAs. So as you can see, I think there's been intentions by the government and previous governments to try and unbundle ZESCO in line with its generation, transmission, and distribution capacities. But this hasn't happened, and there's really no framework for it. The open access regulations do not address this in any way.
Thanks, Bwalya. So, I mean, I think just to step in here from a South African context, what's really interesting is that Zambia very much reflects the structure for South Africa before our Electricity Regulation Act was amended. And South Africa, I suppose, is taking steps and has taken steps to actually unbundle, in that we now have, outside of Eskom, we have the National Transmission, the NTCSA, which is effectively now the transmission system operator, market operator within South Africa, and has key roles outside of Eskom generation and Eskom distribution. It actually is a separate company. So I think that's just an interesting comparison, in that where Zambia seems to me to be where South Africa was about 8 or 9 years ago, where we still had a vertically integrated structure, and we were just allowing open access, captive power, and wheeling. So that's, I think, where Zambia is. There isn't anything in the regs effectively about, in the way that we've just seen with Kenya, about actually changing the sector for now to a competitive multilateral market.
Thanks, Alex. And I think obviously, that's part of what open access is hopefully going to do, to change that diagram and have a lot more participants at each level. So the regulator is the Energy Regulation Board, and their role is to license any entity that's involved in generation, transmission, distribution, and supply. And in 2019, they introduced trading of electricity. So they are the mandatory regulatory body at the moment, and they will issue licenses. They are enforcing the act in relation to compliance. And an important aspect is that they are reviewing and approving tariffs, as well as approving PPAs and PSAs. And what we have seen in our experience is that this is just not a rubber stamp. They are reading the agreements, and they will refuse or reject a PPA or PSA if they think certain terms are not certainly making sense to them. So this is an active role that the regulator, and a key role, is playing on the market.
Yeah. So I mean, I think from a private sector perspective, it's actually wanting to understand from a Zambian government and the regulators' perspective, why they feel that is required. Just because obviously, if there wasn't that step within the Zambian market, it would just open up open access and private generation, fundamentally.
Thanks, Alex, for that commentary. So here we discuss a transition to an open electricity market. And this pretty much comes about because of the Electricity Act, which was passed in 2019. And it provides for open access or a competitive electricity market. Currently, in this Electricity Act, an applicant is able to apply to any transmission or distribution network service provider to have access to their platform and their network. And already they have a period of 30 days within which the TNSP or DNSP must also respond as to whether they can then be allocated space. So the Act also defines what open access is, and it does define it as the availability of spare transmission or distribution to any qualifying participant on non-discriminatory terms and conditions. So TNSPs and DNSPs are mandated to provide open access for use by any eligible participant or consumer. Currently, ZESCO is the intended system operator. But, okay, I'll let you go, move on. So if we're looking at the rationale behind why an open electricity market, for IPPs, I think it was key, and I think here we'll echo what Edwin spoke about in relation to the Kenyan market. It's having market access beyond a single buyer such as ZESCO. It is anticipated that there will be better pricing and contract flexibility. And then, of course, opportunities for differentiation. For consumers, a key point is lower electricity costs. We think this is something that is definitely going to happen in the long run, although it may not be very clear at the moment. But we think lower costs would definitely be a benefit once we have competitive and increased competition at the various levels. And of course, for consumers, it's choice and flexibility. And there's improved service and reliability. And of course, some of them are then also able to meet some of their corporate sustainability goals, particularly when it comes to issues like carbon credits that will become a key aspect when it comes to renewable energy. And for government, the benefit is increased competition and efficiency in the market, as well as a reduced cost of electricity. I think in Zambia, this is quite a topical issue as to whether we pay the right price for electricity. And of course, I think what is also very key for government is encouraging private sector involvement and investment, especially that we have had this energy deficit with the drought that Zambia experienced last year. It is key that government is taking deliberate steps to try and increase and encourage investment in the renewable energy sector, as well as the energy sector in general. And then, of course, to attract investment and innovation, we're looking at more innovative ways of generating power. So we then move on, and what we have in 2024 are the electricity open access regulations. These were passed roundabout in July. So these are key, and they build upon the Electricity Act. And what these basically provide for is that in order for you to be able to apply for access, you must be an eligible participant. And an eligible participant is a person who is licensed by the ERB, or is licensed as a trader and has a trading capacity of over 1 megawatt. Also suppliers who have generating capacity greater than 1 megawatt, and consumers who have a consumption of at least 1 megawatt. So these are eligible participants who can then apply for access. And then in terms of categories, so when you do apply to a TNSP or a DNSP, you would then be classified in this, whether you're a long-term user, a medium-term, or short-term. So if you are needing open access for greater than 5 years, then you'll be considered a long-term user. And medium-term is between 3 months to 5 years. And a short-term, if you need short-term access, that would be less than 3 months. The regulations do provide that the key priority is to ensure a security of supply. Therefore, a TNSP or a DNSP must then consider applications in terms of long-term users first, then medium-term users, and then short-term. What's key to note is that wheeling charges must reflect the cost of maintaining the grid. And the ERB is going to review and approve any wheeling tariffs. So this is provided expressly by Regulation 14 of the Open Access Regulations. And the ERB is also going to prepare a pricing methodology. This is to provide a more scientific and determinable way of determining those wheeling charges, or a fair wheeling price.
Thanks, Bwalya. I mean, I think just the only thing from my perspective, if I look at it just from a South Africa, but also just a broader context in terms of open access in other jurisdictions, is the categories to me, I don't understand the distinction of the categories. And that's very much just because what you usually have is once you sign that wheeling agreement, it's at least in place for the term of the power purchase agreement, obviously because it's needed for the term of the power purchase agreement. And you obviously need long-term tenors in order for the tariff to actually be competitive, that the customer pays. So in my mind, it just seems that why would you ever have medium-term or short-term access? But hopefully maybe participants that have joined the webinar maybe have some insight into that. I actually have asked the question of the Zambian, the team within Zambia that's actually worked on this, just to try and understand it a bit more.
Thanks, Alex. Yeah, hopefully we can get a good answer to that one. And in terms of the roles of the participants, and this is something that the open access regulations do set out, you do have a system operator, and they are responsible for grid operation and balancing supply and demand. And an important role for them is assessing open access by determining if there is sufficient capacity. So they'll schedule open access transactions. They also do have curtailment authority, which means that they can cut off supply depending on what is happening on the grid, and they will have to follow priority. And again, because security of supply is important, so the first people to be cut off would be the short-term users, and then the medium-term users, and then the long-term users. And the system operator is also going to be required to have to maintain a register and a database of information, and also to develop their own guidelines. In terms of the role of the ERB when it comes to open access, they are expected to develop and enforce open access rules and guidelines, and to approve any trading guidelines that might be issued, for example, by the system operator. And again, we talked about this, they have to develop a pricing methodology for fees. Now, how does it actually work in terms of how does open access work? So the regulations do provide that when a TNSP or DNSP is considering an application for open access, they must consider the first come, first served principle. So that's the overarching how we're going to how you're going to have access, or how you should determine an application for access. So, like I initially said, you must first be eligible, and as we've described who the eligible participants are.
Thanks, Bwalya.
And
So,
you,
oh,
okay, go ahead, sorry.
please finish.
Yeah. So like we said, so the participant would then apply to the TNSP and the DNSP, and I think we already mentioned that. And in your application, you do need to satisfy certain provisions of the regulations. The TNSP and the DNSP will write to the system operator, depending on the decision that they make, to determine that there is actually capacity. And if capacity is available, then the participant is granted access and has to enter into that participation and balancing agreement with an SO. That's pretty much how access is envisaged to be.
Thanks, Bwalya. So, I mean, I think all I would say here, I mean, it's exactly the same principle as I went through in respect of Kenya, and that's just that this seems very straightforward. It seems very simple. In practice, we expect that it will actually become potentially a little bit more complicated and a little bit more regulated, actually, in terms of the requirements for the applicants as this evolves. Go ahead, Bwalya.
Okay, and in terms of the wheeling arrangement structure, I won't spend too much time on this. I think because we did talk about it in relation to Kenya, and it's quite similar. Of course, we have ERB granting the various licenses to an IPP, or who would be a seller. And then, of course, we then have the network service providers to whom you would then be making the various applications. Of course, here, as part of the process, you would then have to have approval from the ERB of your PPA and of your wheeling agreement, as well as the various tariffs that you'll have. And then, of course, we have an eligible customer who we've already defined in accordance with the Act. And of course, the system operator, who is supposed to be overseeing the entire grid. Of course, when we look at financing, then we bring in the lenders and the various participants when it comes to that.
Thanks, Bwalya. So, I mean, I think on this, exactly the same as Kenya, bilateral arrangements, heavily regulated. You've got regulator approval of the tariff, of the wheeling agreement, of the power purchase agreement. And fundamentally, what we don't get from the open access regs is how the customer actually receives the benefit of the energy that's been wheeled on the grid for their benefit. So hopefully that's one of the rules or policies that's currently being developed by the Zambian government. Some parting thoughts, Bwalya?
So basically, I think, like I already mentioned, it is a first come, first served basis. But in terms of readiness, because an eligible participant is defined as a person who has a license. In Zambia, by the time you're being issued a license, for example, if it's a generation license, you would have already had in place you'd have gone quite far in terms of project readiness. For example, by then you would have had your tests done, and you would have been moving from commissioning and into actual operations. So that makes us think that perhaps there's a level of readiness that is anticipated. And of course, in practice, in order for you to have access to a network, most of the TNSPs do expect you to be ready to connect almost immediately. The proposal currently is to shift the system operator functions, which would be carried out by ZESCO, to an independent SO and a separate market operator. We anticipate to have guidelines to supplement the provisions of the regulations, which we've just explained. We know that these are currently being prepared by the ERB and the various government entities. So we hope we can have something that will be issued in the near term. And of course, other issues are things like the readiness of our network for open access. And again, the system operator is supposed to submit guidelines to the ERB. So this has not yet been done. So there's quite a lot of work. We're certainly in the very early stages of operationalizing open access, but there's a lot more that I think we expect to see being done and to be done. And I certainly look forward to hearing from our panelists on some of these aspects.
Thanks so much, Bwalya. I'm just going to stop sharing. Give me a second. Okay, great. All right, so now we're going to hear from our panelists. We're very lucky to have, participants from each jurisdiction with us today. And then I think without further delay, I'm going to let Hans introduce himself, who is an energy market expert that, due to the opportunities in Africa, spends more time in Africa than he does in his home in Norway.
Yes, hello. Yeah, thank you, Alex, and nice to be here. Yes, as you mentioned, I've been working for a long time in Southern and Eastern Africa. I think I started in the support for Southern African Power Pool in 2005. So actually a 20-year anniversary this year on the support. I have been lately participating in the support for the development of the market code in South Africa. I'm currently engaged also with supporting some of the other work that is ongoing there. I'm part of the project supporting the establishment of the independent system and market operator in Zambia at the moment, while also supporting a lot of other market reforms, so both Uganda, Namibia, Mozambique, Lesotho at the moment. So I have broad, let's say, experience from the region, and last but not least, also I'm the project manager for the implementation of the Eastern African Power Pool that hopefully will launch very soon.
Thanks so much, Hans. I mean, it's really beneficial to have you with us today, because you really have that, I think, insight into the differences between the jurisdictions. But very importantly, I think how basically that the national market reforms will actually interplay with the work that you're doing in the power pools. I would say that in terms of both sets of regulations, it's light in terms of that interplay, and I'm sure that there's going to be a separate policy that actually deals with that. But in terms of your experience, how do you think that these jurisdictions would actually look to integrate with the power pools?
Yeah, but I think there are two things to consider here. First of all, it's that we need to ensure that the the national regulations are not kind of contradicting the regional ones and vice versa. So there needs to be some form of, let's say, harmonization or interplay between them. However, but what is kind of a key design principle in both the Southern and Eastern African power pool is that they shall not impose solutions on the countries. So again, national reforms, kind of, they remain national reforms, and let's say a regional organization like SAPP or EAPP shall not impose it. So there is a, if I can call it, a looser coupling of the countries, but based on some common principles. And I think this is the design principle for both SAPP and EAPP, and at least for the markets I've been engaged in, we are also trying then to make sure that integration is done in a way that, let's say, don't hamper kind of the regional cooperation, but it also doesn't kind of, let's say, impose some changes to the countries.
Yeah, thanks so much, Hans. I mean, I think those are really key considerations. Just because of time constraints, I'm going to move on to the next panelist, and then hopefully circle back to you. So thanks for that. Henry, hi. Do you want to go ahead? And introduce yourself.
Sorry, Alex, my technology was playing up. Hope everyone can hear me now.
Perfectly. Go ahead.
Great. Yeah. Well, no, thank you very much for this panel discussion. Thanks to the Bowman's team for raising this as a very important, interesting topic. So yeah, my name is Henry Carr. I'm an Energy Policy Director at Cross Boundary Energy. And we're a provider of distributed renewable energy to businesses all across Africa. So we operate in over 10 markets in Africa, and we predominantly provide on-site captive power to large industrial users or mining customers as well. We're very interested in the evolution of open access across the continent as another way of powering businesses and an evolution of the electricity system as a whole. We have actually we are in the process of developing a first-of-a-kind wheeling project in an African market as well. So yeah, excited to share our experiences from that and our analysis as an investor, as a potential investor in some of these frameworks that we're talking about today.
Awesome. So I think, Henry, from an East Africa perspective, we've gone through the Kenya draft regs, and you've heard about what they define as an eligible customer. From your perspective, which customer segments in this market are likely to drive demand for wheeled power? How might their profiles and needs differ from those markets where Cross Boundary is already active or considering going into? And fundamentally, is there a real gap in the market for wheeled power in this market? It would be interesting to hear your view on those points.
Yeah, absolutely, Edwin. So I think important to kind of, when we're thinking about from a sort of end user perspective, and they're looking to improve their power supply, and that might be from a cost perspective. It may be from improving the reliability, or it may be that they want to source increasingly green or energy for their corporate sustainability goals. So I think perhaps echoing what you said in your presentation, Edwin, really the devil is going to be in the detail in terms of Kenya's open access framework, and whether that is going to lead to drive the deployment of a number of open access projects. So the reliability benefit is less clear in wheeling projects compared to on-site projects, obviously, because we are using the grid infrastructure, and so we are reliant on Katraka or KPLC for the performance of that grid infrastructure. As you mentioned yourself, Kenya has a very high level of renewables on the grid as it is, around 90%. And so that sustainability benefit, if you come into sort of renewable energy certificates, then customers might want actual specific projects that they can point to for their power. But I think that sort of picture in Kenya is quite strong already from a renewable perspective. And so we're down to costs, really. And we have not seen any indication of what the costs of wheeling will be in Kenya. And so I think from a sort of mass market uptake, I think that will be the real dictating factor. Maybe just on your point around eligibility. So I think we see around a 1 megawatt level across the continent. I think Zambia, as we just heard, is the case. Nigeria is 2 megawatts. And there is obviously a transactional cost for developing these wheeling arrangements. You've seen from your diagrams, there's a whole host of agencies involved. There's a timeline process. And so agree that as a first market step, that eligibility should be capped. I would say that in Kenya, that the 10 MVA for the transmission level is quite high, certainly higher than we see in other markets. There isn't the same level of really heavy industrial and mining activity in Kenya as we see as perhaps in other parts of Africa, particularly in West Africa and particularly in Zambia. And so really, I think rather than this being a framework which might allow existing customers to access, I see this actually as a potential way for attracting new heavy industrial or manufacturing or just high energy intensive activities, perhaps data centers into Kenya. But then, of course, the success of that is also dependent on much wider regulatory and business macro environment as well. So yeah, I would say that the levels in Kenya seem to be higher than the market standard. But I think that also ties in with what we've heard around the genesis of these regulations, that they are intended more for those larger scale, perhaps hydrogen or data center projects. But really, we think there's a big opportunity for wheeling arrangements to smaller customers who perhaps are limited by space or who are perhaps operating very close to other users and who don't have the ability to deploy significant on-site power.
Thanks so much, Henry. I'm going to move to the next panelist now. If we could, Nutale from CEC, over to you.
Hi, Alexi, and morning, everyone. It's definitely a timely topic, and thanks to Bowman for bringing this up. I think it's not only timely for Zambia, but for the region as a whole. So Copperbelt Energy, just to introduce CEC, Copperbelt Energy is an integrated utility operating in Zambia and with operations in the DRC, but we are and have been a member of the Southern African Power Pool. We are about the largest private trader on the SAP with I guess from that context, we are trading with most all the parties in Southern African Power Pool. Yeah, so I guess that's the business, but maybe yes. My role in the business, I look after the finance business and strategy, and I've been doing this role for the last 11 years, been with the business for 22 years, so spent a decent amount of time in power in the sector. Thank you.
Great. Thank you so much, Natalia, and thank you so much for joining us. We certainly look forward to learning more about CEC and what this means for you. So my first question to you is, what implications do open access reforms have for a utility like CEC? And what steps are you taking to ensure regulatory compliance and strategic alignment with the new framework?
No, thanks a lot, Bwalya. Now, I think the starting point is to highlight that from a regulatory perspective, this is not just for Zambia, but we are seeing sort of a landscape across Africa, I must say, which is sort of beneficial because they are learning points. We can learn from each other. And also it's a little bit complex. I think it's not as easy as most of the parties want to make it seem like. Now, what is it trying to achieve? Essentially trying to push for the very things that you've already highlighted, competitiveness, transparency, efficiency, and also a non-discriminatory use of transmission. I think there is a huge recognition that transmission is a monopolistic asset, and therefore increased regulation and how you allow for a fair play and fair use of those assets for the benefit of the consumer by introducing the required competition in that sense. Now, coming back to Zambia, we've got the regulation, but I think by and large, what is missing are the operating rules which should accompany the regulation themselves. So from a business perspective, what is it that we are doing? We are a part of the technical committees that are essentially formulating these rules, whether we are talking about the balancing agreements, we're talking about the trading guidelines, the transmission and distribution operation manuals, and as well as the market participation agreements. Now, all those things are not yet in place, but we've got the rules. So how are we going to ensure that from an operational perspective, the rules that we are coming up with, they do speak to the regulation, but also I think the second aspect, which is quite important, which is that the market is not yet financially sustainable as a whole from a Zambian perspective. Now, in making that comment, I'm referencing the last cost of service study, which is on the ERB website, which you have access to, right? Now, if you have those sorts of permutation, what you don't want is to essentially collapse the market from a financial sustainability perspective. So we need to tread carefully, make sure that the parties that are financially sustainable are not pushed, essentially pushed to a position where they're not financially sustainable. So what we need is also to ensure that as part of the process of unbundling and ensuring that we have costs reflective tariffs, we recognize which areas will require or continue to require, to the extent that there are subsidies that are available, so that we attract the investment. Otherwise, we defeat the whole purpose of what we are trying to achieve, whether it's investments on the generation side, as well as investments on the transmission and for the benefit of the users. So from a business perspective, one last point to just highlight is that the whole regulation requires us building sufficient capacity, which capacity probably we didn't have, upskilling, but also there is an important aspect, which is just investing in the required tools to allow for parties to come and apply and make sure that you can do these things in real time, but also you're doing it in a very transparent manner, very objective, to bring the right integrity that is required to the market.
Thanks, Mutale. I mean, I think a lot of food for thought there, and just obviously very interesting to hear your perspective as a transmission provider. I'm going to hand over then now to Pranisha from Rand Merchant Bank, and obviously really important to hear a funder's view of the open access framework. Thanks, Pran. Do you want to go ahead and introduce yourself, and then we'll get into it?
Sure. Thanks. Good morning, everyone. And firstly, thank you to the Bowman's team for the opportunity to be a panelist today. My name is Pranisha Sahadia, and I am a transactor in the Infrastructure Sector Solutions team at Rand Merchant Bank. We look at a broad range of infrastructure and renewables transactions. In fact, we've funded over 2,400 megawatts worth of renewables projects, both in the South African sector and sub-Saharan African sector as well.
Thanks so much, Pran. So, I mean, I think the key question then, I think, would be that as a transactor that actually funds these projects in Africa, from a bankability perspective, what are the key things that you look for from a regulatory framework in basically determining whether you would fund a project or not?
Sure. I'm just going to pick a few bankability criteria because we can go down a rabbit hole as it pertains to bankability.
Yeah, agreed.
But firstly, I think and this touches on regulation, but it's an important point I wanted to raise, is that we want to see a stable political climate which attracts renewable energy investments. We want to see that respective government has publicly expressed support for renewable energy, and that there are policies and incentives in place in order to promote the development of renewable energy. So I think it goes to things like, is there an integrated resource plan? Has that been regularly updated? Are they tracking their goals? So it is a little bit of a softer consideration, but I think an incredibly important one. Secondly, I think, and we've been discussing this, an established wheeling framework is critical. Banks often will ask themselves, as it pertains to off-taker default risk, do I have the ability to wheel power to an alternative off-taker should my primary off-taker default? So it's critical, and I think you've mentioned it, Alex. In the South African sector, we have the connection and use of system agreement, and we have the amendment to the electricity supply agreement, which clearly defines how power is provided to that end user. So this, having this clearly defined will assist in bankability and also helps things like stretching out of debt tenors. And then lastly, I think the issue of curtailment is topical. We need to clearly understand who is responsible for the costs of curtailment. Typically these projects are funded on a project finance basis. So it's quite difficult for the project company to assume that risk. So we would need to see that there are clearly defined rules as it pertains to who assumes the risks or costs associated with curtailment.
Yeah, I completely agree with all of that. And I think in South Africa, we've really taken strides to address all of those issues. So definitely there's that interplay that we can have with the Zambian and Kenyan regulatory authorities in terms of what's required. I'm going to just, we're running out of time, and what we'd like to actually do is just actually extend the session by potentially 15 to 20 minutes, so we can actually hear from our participants and actually have some engagement with our panelists, because we're really fortunate to have these individuals with us today. So I think on that note, what I'm going to do is I'm going to actually open it up to questions from the participants. They should have been coming through on the chat. Anele, so if you want to go ahead and maybe let us know what the first question is, and we can allocate it to one of our panelists.
Yes, sure. Thanks, Alex. There are a number of questions that have come through the Q&A box. Some have already sort of been addressed directly in the chat by one of our panelists, so do keep an eye for that. Well, now, the first question is from Ward. Would you expect direct agreements between lenders and Ketraco to cover risk of being stuck with an IPP that cannot will? I think that question would be for Edwin.
Yeah, the risk is there and it's recognized. I'm not sure if direct agreements would be the go-to solution. Alexandra, I don't know if you've encountered this in the South Africa market and how you've dealt with it.
Yeah, so we do have that. So there would be a direct agreement in respect of we do have that in South Africa. So there is a direct agreement in respect of the connection use of system agreement. So we would expect that there would be the equivalent structure in Kenya and Zambia as well, to give the lenders obviously their step-in rights and the opportunity to effectively substitute the seller to the extent that they need to, if there's a default under those agreements.
Thanks, Alex. And the second question is, in South Africa, how does the credit work if the consumer is not buying any energy from Eskom?
Yes, I mean, in terms of, so it's going to change under the, as I said, that we actually are evolving also to a competitive multi multi-market model. And then there's still questions about how it will change. But currently, I mean, the way that you wheel, the projects that have closed in South Africa, you are doing them with Eskom. So it is that the consumers are buying majority of their load from Eskom or municipality, and that's a topic for another day. In South Africa, it's a bit tricky to, as it is permitted to do it with municipalities, but we actually aren't actively doing those at the moment, because municipalities don't have, most municipalities do not have approved wheeling tariffs and wheeling frameworks, but Eskom does. So no, so in South Africa, we the ones that have been closed and the ones that we're actively working on, you always have that Eskom supply, so the credit is what's passed.
Great, thanks, Alex. This next question is for Bwalya. ZESCO tariffs used to be lower than cost. Is this still the case? Are private bilateral contracts open on tariffs, or does ZESCO still regulate the tariff?
Okay, so ZESCO doesn't regulate the tariff, so ERB does. In terms of whether or not they're lower than cost, I think that's something that is really subjective. But Mtale, happy for you to jump in here. What are our thoughts on whether or not the ZESCO tariff is cost effective? Because that's cost reflective, because that's something that's always been a point of discussion.
No, thanks, Bwalya. I guess the only document that we have to speak to this point is the cost of service study, which was last done, and this is a document that I believe should be on the ERB website. Now, that document does highlight that ZESCO is selling below cost for the power, and the recent application that we saw for the emergency tariffs did also highlight the fact that the tariffs as of today, they're still below cost. So there is need to move the tariffs to cost reflective levels. Thank you.
Thanks, Brutale.
Our next question is, what does the interface to the SAPP day-ahead market look like? Are customers or private entities able to buy and sell from SAPP as far as there is spare transmission or distribution capacity available?
So I'm going to hand this one over to Hans.
The short answer is yes. That is kind of one of the core. So I presume this question comes from Zambia, where the interface to SAPP actually is a key part of the open market guidelines that let's say hopefully they are in the open domain now, and the core of this, or the base of this, is that eligible market participants shall be allowed to buy and sell directly on SAPP. And the same actually, if you look at South Africa, it will be done a bit differently, but still you will have that opportunity. It will be the same for Uganda. It will be the same for many of the other countries in the Southern African region as well. So to allow for let's say multi-market access is also one of the key things behind also the power pool operation of this. Yeah.
Thanks, Hans.
Thank you. Next question is, what are the wheeling charges in SA, Zambia and Kenya for an IPP that would like to sell electricity to a corporate off-taker connected to the distribution or transmission network?
So I don't think that's actually one, unless one of the panelists has the commercial answer, that's not actually one that we can answer in this forum. So maybe we move on to the next one. I mean, I think under Kenya and Mutale, you might want to comment actually from a Zambia perspective, if you have any insight at the moment. Yeah, go ahead.
Yeah, no, happy to comment. So from a Zambia perspective, at the moment we've got the open access regime. However, one of the work streams that is going on is to ensure that the utilities unbundle the tariffs, because at the moment we have a bundled tariff.
Yeah.
Now, once the tariffs are unbundled, then you specifically know which component of the tariff relates to generation, which one relates to transmission, and which one is for services. What you will see is that there are three transmission providers in Zambia: ZESCO, CEC, and Northwest Distribution, and all of them have created what are called online application portals. So to the extent that you require additional information, you can go to any of those, and there'll be information on the online application portals, which are live and operational in all cases. Thank you.
Thanks so much. So in a South African context, it varies in terms of the point where you're connecting at. So it's not a straightforward question. Anili, should we move to the next question?
Sure. Can you elaborate on the EPRA sign-off on tariffs between the IPP and the buyer?
Bwalya, do you want to go ahead?
I think it's the EPRA. That's EPRA.
Oh, it's you.
Sorry, PRA. Yeah, PRA. Sorry.
Yeah. We are anticipating regulations around this that will give more detail on what goes into the assessment of what the tariff should be. But generally, there's a framework under the Energy Act that says, tariffs have to be fair and reasonable, and they have to reflect the cost of the power while balancing customer interest and making sure that the industry remains attractive to investors. So we'll wait for those regulations on more details.
Henry, do you have?
Yeah,
I was just about to hand over to you. Go ahead.
Yeah, sure. No, I was just going to jump in off the back of that. I guess I think we see these requirements in energy laws across the continent more as a very fair and understandable means of protecting consumers who are obviously not directly negotiating the cost of power, which they ultimately will have to pay. So I think maybe just a caution. Obviously, regulators should be able to approve and review and make sure costs are competitive for consumers. But what we're talking about here is a charge which will be freely negotiated between two private entities. And a whole host of factors will come into how that is arrived at. And so I think visibility is one thing, but approval from regulators on that tariff, particularly when you think of perhaps the potential influence of utilities on that process as well, we really strongly advocate that regulators do not play that role because that has an ability to actually stifle these sorts of projects.
We couldn't agree more on that, Henry. Sure, Nela, next question.
Thanks, Alex. Bit of a long one. Bear with me. KPLC charges consumers more than double its average input cost of power. Ketraco currently generates more revenue. That suggests the cost of the grid is at least 50% of the current tariff and more if Ketraco assets are also cost. If KPLC or Ketraco become system operators relying on wheeling charges, the cost will either be prohibitive or the revenues will drop sharply. Ketraco revenue should increase from nothing. Has KPLC confronted this yet?
So I think unless Edwin and Henry do want to come in here, I mean, I think it's an excellent question. It's just one that we can't answer.
Yeah, we can't say whether KPLC has confronted this, but as Mutale mentioned, there's a process of unbundling of the tariff that is planned in this country, and ideally, what that will do is we'll be able to see what percentage of electricity cost goes to generation, transmission, distribution, etc. There are also a lot of transmission service providers, private transmission service providers looking to come into the market. We are currently advising the one that is most advanced. We know that Ketraco are going to go to market on a PPP basis for a few transmission lines. So it's essential for the sector that unbundling happens, so that it's attractive to not just transmission service providers, but every segment of the sector. So, Henry, do you have anything to add to that?
Not really. I mean, I don't want to be too negative or skeptical. I mean, hopefully no one from APRA's on this on this webinar, but I think this talks to perhaps some of the skepticism I spoke through earlier. Because if you think about, charges being one thing, but also the role of, as the regulations are quite light on detail, but we know we have to negotiate wheeling agreements with Contracco and KPLC. To what extent are those entities forced or mandated to actually execute those agreements? I mentioned the experience we've had in another market that took us 16 months to negotiate a wheeling agreement from scratch. And that was with a lot of senior political support. So I think just, the economics, there's an economic issue potentially, but how that actually translates into how these agreements are actually negotiated, how these projects can actually be taken forward in a realistic time frame is also something that is a potential real impact as well.
So I'm trying to think what's worse, the fact that you had to negotiate a wheeling agreement for 16 months, or the fact that in South Africa, ours is a standard form that you either accept or you don't get grid access. So
I think ours was worse, actually, I'd say.
okay.
Yeah.
Okay, sure. Nelly, next question.
What are the primary bankability concerns associated with the conception or development of the Eastern Africa Power Pool?
Hans or Pran, whoever, if you'd like to respond on this one.
I can start with the more practical.
Sure.
But again, if you look at, for instance, the ideal situation is that with EAPP becoming operational, it means that as a potential investor, you have a much larger offtake, let's say, market if you are going to invest in generation. So again, if you look at, for instance, what has been done in Namibia, and we see that kind of projects are coming online where this has been their kind of very clear policy from the government to say that we are actually going to assist in providing access to the wider region for national projects. Which means that they can attract more investment into a small country with the whole of Southern Africa as an offtake. And hopefully we can see somewhat the same happening in Eastern Africa when you get the pool operational.
Thanks, Hans. Pran, anything you want to weigh? Go ahead.
Sure, no, thanks. I think I can maybe weigh in from the perspective of, funding projects that sell exclusively into these power pools.
Yeah.
I think the trick with it is that, obviously the revenues are quite irregular as compared to your normal bilateral PPA. So it is something we've had to wrap our minds around from a bankability perspective. So what's quite important to understand in respect of these power pools are the market supply and demand dynamics. And the forecasting of what that's going to look like over the next 10 to 15 years. So I think that's quite an important, bankability consideration. We have done a lot of work in that regard as it relates to the Southern African Power Pool. So we are excited to see, what lies ahead for the Eastern African Power Pool as well.
Great, thank you. Next, I think maybe just two more questions, Anele.
Yeah, and also if we're unable to sort of like cover all the questions due to time, we'll ensure that they are reviewed afterwards and all responses will be shared with attendees where possible. This question is around construction without having secured access to the grid. Are lenders comfortable with advancing funds in the absence of the secured grid access?
Definitely for you, Pran.
The short answer is no.
Yeah.
Yeah,
there is no project. There's no project without grid access.
And maybe just to add to that, Alex, perhaps because of the level readiness or the project must have for you to apply for open access. Perhaps what the alternative would be for you to have a bilateral wheeling agreement or connection agreement, as opposed to the use of open access.
Thanks, Bwalya. Our last question, this is a two-part question. In your view, what operational and financial risks could result in a scenario where Kenya implements open access before expanding its generation capacity? Second question, how might this impact system stability, seeing as we are now possibly experiencing the onset of curtailment?
Edwin or Edwin or Henry, I think.
Yeah, I think it's one of those challenges which I mentioned in my presentation. I think he meant transmission infrastructure rather than generation capacity. We have a challenge, but as I said, there's a lot of there are a lot of projects that are in the pipeline. As I said, we're advising on the most advanced one. Ketraco is going to go to market on an open tender on a couple of lines. There's a lot of investment that's required in the transmission space, and that's still an open question, to be honest. We are not sure whether the current transmission infrastructure is up to par with an open market. Henry, any thoughts on this?
No, I think I just stress, I think, we're obviously deep diving into open access regulations, but actually what we're seeing is that, there are a whole host of improvements that need to happen to enable open access. And so I think that's what EPRA are trying to do, situating this in the evolution of the power market more broadly. But yeah, it's a very, very good point. And to the extent that open access regulations are a good stimulation for these sorts of improvements, and we're very, very supportive of that. But I definitely agree with the question that there are kind of very real operational challenges around these sorts of projects, as currently is.
Thanks so much, Henry. I think we'd go to closing remarks now. Henry, just because you're on screen, do you want to go first?
Sure, yeah. No, I think I think we focus quite a lot on the cost of these solutions, how they fit in with perhaps some of the challenges that utilities are facing, some of the issues around grid infrastructure. I think it's also really important to note that these are complicated projects that require engagements from a whole host of different parts of government, grid system operators, network owners, and customers. And so I think equally there's a focus on developing the rules. There needs to make sure that there is the capacity within these organizations to actually execute what are very complicated projects. I think in our experience, we've seen regulatory frameworks which are very supportive to deploying projects, and that we haven't been able to take them forward just because of the time or the time it takes to do that. So I know these sorts of institutions across Africa are very under-resourced, and so I just encourage regulators and governments to think about that just as much as they're thinking about actually developing these rules themselves.
Thanks, Henry. Pranisha, do you want to go next?
Sure. I think as a banking institution that's active in the sub-Saharan African markets, what I will say is that we are very excited to see the move towards an open access market in both Zambia and Kenya. Whilst there is work to be done, I suppose, in terms of a defined wheeling agreement and also key issues like curtailment, we're very excited about the developments, and we kind of look forward to working with key industry participants to bring some of these very, very important projects to fruition.
Thanks, Pran. Hans, over to you, and then Mutale.
Yeah, but I think just to piggyback on what has been said by the previous ones, I think one of the key things that I also feel is missing a lot in Southern and Eastern Africa is transparency, right? In a lot of different levels. So for instance, where do you find all the rules, regulations for each of the countries, for each of the so for the power pools, to be honest, it's really bad, right? So and I think this is kind of one place where everybody can be better, even though some regulators are much better than others. and also to foster more cooperation and exchange of experience, ideas between the countries. So again, as Alex would know, we just had a study tour from Zambia to South Africa, and to get an engagement going between countries to exchange ideas and learning, I think is great. I know there is a regulatory cooperation with a few regulators in Southern or in Africa in general. I think more of this will be extremely important, because then you can hopefully tear down some of the barriers for both investments, but also for better integration.
Couldn't agree more. And Mutale, over to you.
No, thanks, Alexis. I think for me, it's just to say that we're quite excited as a sector. We will want to see more regional trade. I think with the Zambia-Tanzania interconnector being done, we hope that we could see trades from Cape to Cairo type transactions going through. But we'll only achieve that if there's alignment between the policymakers in all these countries coming together to make sure that there's alignment from a policy perspective. The second one, which is important, everyone has mentioned it, it's around regulation as well. Make sure that it's transparent, everyone knows what the rules are, and that we try to activate the trades that we want. And more importantly, there's a recognition that all along the public sector sort of funded these infrastructure projects, but now we need more of private sector financing to come into, not just in generation, but also in transmission, because most of these interconnectors can be financed by the private sector. But in order to do that, we need to address all the issues around bankability, make sure that the investors can get their returns in a safe manner, the risk allocation is done right. And I think for me, those would be my closing comments. Thanks.
Yeah, I mean, I think that's exactly right. And just related to that, I mean, from a Bowman's perspective, our view is that sort of participant private sector engagement on any sort of market reforms or new rules and policies is fundamental. I mean, I touched on a few times in the presentations where South Africa started, where we've gotten to, and where we're going to. And a lot of that in terms of our bilateral private generation, bilateral space being heavily regulated. The way that it's actually played out now, that it is largely commercial arrangements that are unregulated, and the only aspects that effectively are regulated is that use of the grid, you know, occurred through a lot of private sector engagement and you know, participation and comment on rules and policies in order to get where we are. And that's something that, you know, fundamentally Bwalya, Edwin and I are looking at in the jurisdictions in terms of trying to get it to, you know, work in the best way possible for investors, funders, generators, and obviously, of course, electricity consumers. So a lot of discussions to be had on these topics going forward. With that, I think I would just like to obviously thank our panelists first and foremost. Thanks so much for making the time to be with us. You gave us a lot of food for thought. And thank you to our participants for joining us. The presentation, the recording will be available as well as the presentation, and any questions that haven't been addressed will be addressed as well. So thanks everyone, and have a good day forward.
Bye-bye.
Thank you.
Thanks all.